My fellow Ambalanders, Shake Day. This is Dr. Choayaba. I want to talk today about a series of issues, and I would like to be as slow as possible. What has kept us going up till this moment foundationally is knowledge. Knowledge has been very critical in understanding the barbarians, understanding our history, and the historical manipulations that have been used to weaken our resolves. And these manipulations have been propagated by our own. So sometimes it comes across as something to be considered, something making sense. Yesterday, I listened to an audio. I couldn't listen for long. I thought it was disgusting. It came from Dr. Akwanga. I will not talk about the content of the audio. What I want to address are the motivations behind some articulations that are being propagated out there. They are around the issue of international process of resolving our conflict versus a domestic approach that is preferred by the barbarians and their enablers within Amazonia. And I want to use this opportunity to explain to our people certain facts which will inform everyone about our decision, which will not change, will not be negotiated, about how and where the issues around the conflict shall be adjudicated. The question of where a conflict is resolved is an issue of the framing of the international system and international rules, laws, and norms. It is not only about conflicts, it is also about the primacy of the state as the primary arbiter of issues concerning individuals or remedies about violations. I know this may sound a bit complex. Let me break it down. Under international law, the state is the first jurisdiction where issues are dealt with. For example, when states sign multilateral treaties, let's say human rights treaties, take the case of the International Covenant on Civil and Political Rights. The international system does not have, kind of courts or other jurisdictions that you can easily deal with rights violations or instances where parties to treaties undermine treaties. They kind of exist, but they do not have enforcing powers like courts, where you have the police and you have other judicial authorities that can enforce outcomes of decisions by courts under the powers of the executive or the legislature. So what happens is, if, for example, your right to free speech is violated or you are tortured, you have to first bring a case within the state within which you live. you follow all the instances. It might be, for example, customary adjudications where you take it to the quarterhead, they try to resolve it. It doesn't, you take it to the court of first instance, and then you start escalating high court, and then you can take it right up to the Supreme Court. And if you do not find a solution, and you can escalate in the case of the International Covenant on Civil and Political Rights, the next instance is the Human Rights Committee. It usually sits there in Geneva to examine cases all the time. That's where Mukong took his case, Akwanga took his case, Gorgie and others have taken their cases after they could not get remedy from Cameroon. So the way the international system is structured is such that international laws and practices are not there to replace domestic primacy in dealing with these laws and practices. It is supplementary. But what if, so the international law says you must exhaust domestic remedies before you take your case to the international system. But what if domestic remedies don't exist? Or if they exist, but they do not provide a chance of success, or they take so long that justice delayed becomes justice denied. So when you file a case at the Human Rights Committee, you have to show cause, you have to show proof, you have to provide evidence